So recently we had a person comment on a video on Facebook about Miranda rights, and they asked the question if they had not been read their Miranda rights, if they could get off with a warning. Well, first of all, police have discretion as to whether or not to charge a crime, so whether or not a person is going to get a warning or is going to be arrested or given a citation is completely up to the officer's discretion. It has nothing to do with whether or not you're read your Miranda rights. The more substantive issue there is, having been read your Miranda rights, what does that do? Miranda rights are designed to advise people of their rights and, your right to remain silent and to have an attorney appointed to represent you. I'm sure everybody out there knows what Miranda rights sound like because you've heard it recited in the movies a million times. What happens if you are in custody, and custody it's not a simple analysis. If somebody is in custody, in police custody, and they have not been read their Miranda rights, and they make statements that the police intend to use against them, what a court should do is suppress the use of those statements, meaning that they exclude it from evidence, because the statements have been taken involuntarily because the defendant has not been what is called Mirandized. They haven't been read their Miranda rights. So if the defendant makes admissions that the prosecutor would use against them in the course of the trial that eliminates your Fifth Amendment right to remain silent, and the defendant made those statements while they were in police custody without having been read their Miranda rights, those statements should be excluded from evidence. That's really the legal issue that was at play in the question that we got from one of our visitors to the website, our Facebook page.